Let me introduce myself first of all. My name is Simon Cole. I'm Vice Chair of the General Union, and I'm responsible mainly for dealing with the schools and the colleges side, the educational trusts and things like that, private high schools, elementary schools, universities. But I'll be dealing with the law as a whole, and I'll deal with things that affect all areas of education in particular. Now, first of all, the first law that we're going to look at, which has major effects on conditions and things at your workplace, is the Labour Standards Law. Now, if you look in the book on page 1, the first thing to note is that this law is enforced by an office called the Labour Standards Office, or Rojo Kijun Kantosho in Japanese. And it's different from a lot of the other laws in that this office actually has police powers. If an employer breaks this law, they're actually breaking criminal law and can be prosecuted. It's not like some of the other laws where you have to sue or take legal action yourself. The office takes legal action against a company or an employer that breaks this law. In that sense, in theory, it's the easiest of all the laws to apply and to get usefully used to benefit yourself. In theory, and I'll deal with a few problems of that in a little while as we go through it. Now, first of all, before we do anything else, under general, I'd like to deal with the second question first. My employer told me that since I'm a foreigner, the Labour Standards Law and other relevant labour laws don't cover me. Is that true? No, it's nonsense. If you're a worker, you are covered by this law. Now, what's a worker? You might think it's simple, but it's a little bit more complicated than that, because in education, there are a number of sectors that aren't classed as workers under this law. For example, teachers who are civil servants, okay, and that's full-time Japanese teachers or various others working for boards of education. This is not universities, not even national universities, but basically public boards of education. They're not covered by this law because they're classed as civil servants. And unfortunately, from next April, sections of people who are now directly employed assistant language teachers will not be covered by this act because they become a new type of civil servant, to financial year limited civil servant. So, but with those exceptions, most people are covered. Now, there's one more.
Sorry, I was going to ask about, for example, at Kansai Gaidai, they have people who are technically employed by, like, the University of Texas, but they're working in Japan.
Well, yeah, that's a little bit more complicated, but they're definitely workers under the Labour Standards. Okay. So those people we can probably deal with. I think Dennis may be dealing with that under dispatch issues and things like that. But there is one section that I've missed out here. You may come across some pretty terrible employees who claim that you're not a worker. They'll give you orders, tell you where to work, you'll have starting time and finishing time, but they'll claim that you're not a worker in an attempt to get around these laws. And probably the best known employer like this is GABA. And with GABA, at least you have a certain amount of time to choose when your classes are and things like that. There's another much less, well, they're about the same actually. There's another company that's probably more infamous, Nova. And Nova actually have created a new class of teacher who basically do the same as all the other teachers, but they're contractors. And they claim that the labour laws don't apply to them. However, we've fought a legal case against that, arguing that they are workers, and we've won at the lowest level. They're appealing to a higher level, but the court ruling is so far that those people are workers. And I think at GABA as well, we'd actually win that case. If your employer controls your labour, gives you direct orders what to do, doesn't allow you to subcontract your teaching to friends or whatever, then clearly you're a worker. If tell you where you have to work, what time you work to, give you rules that you can't do this. And we have had these things. We're dealing with a case now at Dorsetshire Elementary School where they've dispatched people in there, and the company claims they're not even the dispatch company claims, oh, they're not our own employees, but they were even told how to stand in staff meetings, and that they were disciplined for not standing properly in staff meetings, which is interesting. Okay, so, but most of you here, I would imagine, if you're working and if you're employed, will be covered by the Labour Standards Law. So the first question is the question 1 at the top. My contract and the Labour Standards Law are different. Does the law or my contract take precedence? If the conditions in your contract are worse than the minimums in the Labour Standards Law, the Labour Standards Law takes precedence. If any of the conditions are better than the Labour Standards Law, then your contract takes precedence. So the Labour Standards Law is a minimum which no worker is supposed to fall below. So that's the key thing here. And employers, it specifically states that employers cannot use this law as a reason to cut conditions. So if your employer tells you you have too many paid holidays and the Labour Standards Law says they only have to give you this many, they're actually, it might be difficult to do much about it, but other than organise a union, but they're not supposed to do that, and it specifically states it shouldn't be used as an excuse to do that. Okay, so let's move on. Now, what does the Labour Standards Law say about contracts? First of all, it says some things about the length of a contract. In Japan, there are basically 2 types of contract, and we'll come on to this in more detail later on. There's a contract with an unlimited period, and then there's a limited term contract. And the limited term contract is, the maximum it can be for is for 3 years. So there is one exception, and that's some people called ninkisei or ninkitsuki at universities that are supposed to be linked to certain projects, and they can be up to 5 years. So, but that is an exception. Everybody else except for this specific group, I can't think of any other exceptions. Maybe Toshi will correct me if you can think of another exception, but almost everybody else you're limited to 3 years. I know most people who are on limited term contracts will be on 1 year contracts, but there is a limit there of 3 years. Okay, the second section, and this is quite important, things that your labour contract should include. It should include the following: the length of the contract, the wages, and the set working hours. If your contract and the actual working conditions differ, you can cancel your contract immediately.
I have a question. So, at our workplace, our hours are measured by teaching hours, but we actually work far more than that. How does that work out with contracts?
Okay, now, if you're working more than your contract states in there, and then you should be getting paid for that time. And we've had kind of various battles at conversation schools like Berlitz for the period in between classes where people are supposed to keep records, do various things connected to the class and that, and they may be allowed to go to the toilet in that time. And they, in the past, weren't paying for that. I can't say much about it now, but anyway, we've taken that issue up with Berlitz. So what else? What else? The only thing is, it's a little bit difficult if they're not actually telling you what to do in that time, and if they say no, you're free to do what you want in that time. So it can be contested. I mean, that's probably your best bet there, is to join a union and actually push and negotiate with them to get that time recognised and paid. The labour standards can come in and do an investigation. In my experience with teaching at schools and that, sometimes they've done it, but they've been a little bit flexible, because even the teachers themselves expect that you're going to do some work outside of hours. So it's not some cases it may be a little bit difficult, but for example, they could come and look at, if you're expected to do work that's clearly outside of the teaching hours and the contract, they could come and look at that and say, no, you should get paid for this work. You know, it depends. There are a number of kind of ways they can get around it, but yeah, you should be paid for all the work you do, not just the teaching hours. If a lot of people who work at universities, they have 1.5 hour classes, but most of the universities say that the working time for that is 2 hours. Sometimes they say it's not really, and we argue about it, but basically that's a recognition that there's substantial amount of work outside the teaching hours there, and our argument is teachers should be paid for that. Does that answer the question? Yeah. Labour standards would be the place to deal with it, but what I advise you to do is probably talk to us first about it and give specific details, and then we can look at, you know, the best way to handle it. Because sometimes labour standards are busy, and if they don't think it's something that's easy to enforce and win, then they, well, may not push it to the extent that it should be pushed in our view.
Thank you.
Okay, what else? Methods of deciding on calculating and paying wages must be clearly stated in a written document delivered to the worker. Furthermore, based on an ordinance, employment contracts must state whether they are renewable, non-renewable, or renewable based on performance. Now, this is actually quite important, because if you're on a 1-year contract, they will often try to get rid of people just by not renewing the contract. But the contract is supposed to say whether it's renewable, non-renewable, or renewable based on performance. So if your contract says it's renewable, that gives you a stronger case than if it doesn't say for renewal. Outside of my contract, are there any other workplace rules that I should know about? Yes. There's the workplace rules called the Shugyo Kiso. And this is a little bit problematic because the employer can change these rules without reference to your contract. Well, they can't supersede what's in your contract, but something that's not written in your contract, your employer can unilaterally, and not quite unilaterally, can change things in the working rules. And your contract may have something in the contract that says, basically, other things are governed by the working rules, okay? And the working rules should be displayed publicly in the workplace for the different groups of workers, but in my experience, often they're not, and you have to go through quite a lot of trouble to get them from the personnel department, very often. But they're actually very important. And if the employer changes them, they have the responsibility. I said they could change them unilaterally. They can. However, if there's a union representing over 50% of the workforce, they need to get the opinion of that union. They don't need it to agree. They need to ask it for its opinion on it.
Can I interrupt?
Yeah.
Is that 50% of the workforce is in a union or the union?
No, it actually says a union representing 50% or more of the workforce. So it's a union. But there is another way, a workers' representative elected by over 50% of the workforce. And often you'll find that your workplace does have a workers' representative. And sometimes employers, some people get angry. Well, they're not our representative.
Mm-hmm.
They've not done anything for us. All they do is sign that they've seen the work changes. They don't tell us anything about it. And employers tend to say, oh, well, no, it's not your representative. It's a workplace representative.
Mm-hmm.
They just have to sign off on an agreement that makes you work overtime, which employers need if they're going to get people to work overtime. So this is a workers' representative. And it's not very good in a way, but sometimes we've stood union members as workers' representatives. And it's useful in that you get to know changes in the working rules and things like that. But the working rules system is a weakness in it, because it does allow, you can have a clause in your contract that says these are the working rules also apply, and then the employer can unilaterally change those things. But they can't change it to breach anything that's in your contract. So that's a thing to watch. Okay, where are we? Let's move on, shall we, to page 3. First of all, at the top, there's a little bit more information about the working regulations. And, if anybody has any questions, you can ask now or any more on this section. No? Okay. Okay, next thing, firing, quitting and contract non-renewal. I want to quit my job before the end of my contract, and now my employer won't pay me this month's wages. He also wants me to pay a fine of 1 month's salary. Is this allowed? No, it's not. The employer cannot withhold wages, and they can't even set a penalty in the contract for breach of contract under the Labour Standards Law. They can't do that. Now, can you leave? Now, there's various things. I think the civil law is 2 weeks. Am I right on that? 2 weeks' notice is generally agreed. But there is a certain problem with contracts in the first year of the contract. If it specifies notice in that contract, and you're in the first year of the contract, or your first contract, rather, sorry, I should say, if it's a 3-year contract, it's within 3 years, then the employer could have a possible case for breach of contract against you. We know of a few cases where this has actually happened in schools and things, in conversation schools and things like that. It's supposed to, the liability is only for actual loss, and they would have to show that you leaving cost them money and there was no other way around it. And so things where they paid somebody's airfare over and they've left very quickly, something like that would be a case possibly that they could win. When contracts have been renewed, it's much more difficult to do that. And this is one of the reasons why there's a maximum on a limited term contract, because an indefinite contract, you're free to leave when you want, there's no problem. But a limited term contract, for the duration of that contract, it's far more difficult for the employer to dismiss you until the end of the contract. And also, there's a case if you leave early for breach of contract there. So that's why the maximum is 3 years set there. It used to be 1 year. And the reason is the idea that you could have some power to force somebody to stay for over 3 years is unreasonable. I think forcing people to stay in a job they don't want to is unreasonable, full stop. But that's basically what the law says there. Okay, my employer fired me suddenly. Am I entitled to anything? Now, yeah, in theory you are, especially if it's a limited term contract, as I've said. But the fact of the matter is that the Labour Standards Office won't get involved normally in cases of dismissal. Not normally. They might call the employer and ask for a reason or something like that, but they won't get involved in this. And you'll have a choice of fighting this under the civil law if it comes up, which can take considerable, well, you're talking years, not months, if you use the civil law to fight a dismissal case. And then, of course, then there's the problem of what you do while you're dismissed. So that's problematic. It's stipulated, so that's problematic. And if anybody has any questions on dismissals, it's a big subject, and it goes beyond the Labour Standards Law. But and just to be clear here, a non-renewal is not the same as a dismissal during duration of contract. However, and we'll come back onto that, if after multiple renewals, it can be virtually the same if you have a strong expectation, legally reasonable expectation of renewal. Okay. It's stipulated in my contract that I can be fired without notice during a 3-month probation period. What does the Labour Standards Law say about this? 3 months is too long. There are probation periods, but I believe, what does it say here?
14 days.
14 days, yeah, so it's nowhere near 3 months. They can't give you, you can't have a 3-month probation or something like that. I've heard of people saying there's a 6-month probation or something like that. No, they can't. The probation period is 2 weeks here.
Is that
Okay.
for all industries or just for teaching?
No, this is for all industries, so not just teaching, not just education, but all industries. Okay, can my employer not renew my contract without reasons? Now, I explained earlier that the contract has to say whether it's renewable or non-renewable in there. And in the first contract, the employer, I think it's when you hit 3 years, is that right, Toshi? 2 renewals.
Yeah.
2 renewals, the employer has to give you a reason, and you can ask for a reason.
Three.
3 renewals. So two renewals.
3
3 renewals. So 4 years if it's a 1-year
Yeah,
contract.
4 years.
Okay. Okay. So that's 3 renewals. Longer than that, and your employer has to give you, from the 4th year, if it's a 1-year contract, the employer has to give you a reason. Until then, they don't have to.
By writing.
By writing, yeah. You can ask for it, and if a union goes and negotiates, they have a duty to give a reason if we ask, because they have a duty to negotiate in good faith. So we can ask, what's your reason for doing this, and they will be obliged to give us a reason. But they don't have to give you, if as an individual, a non-union member, you leave, a reason until the 3rd renewal. There.
Say you make a mistake in that last contract and they use that as a reason to let you go and put it in right, that's acceptable, right? If you make a terrible enough mistake.
A mistake. What kind of thing are you thinking of?
Okay, one day I forget to go to work.
And
Hypothetically.
you don't call in sick. Well,
Right.
yeah, they could fire you during the contract.
Okay, and what happens if, in my first year, one time I didn't go to work? They can't hold that against me 4 years later, can they?
There's nothing in the law about this. I don't think that would be reasonable. But again, this would be a civil law question. You know, if there's nothing written in the labour law that says what would be reasonable there. You have to look at case law
Okay,
and what
so,
courts have decided.
anything within the last 4 years is fair, not, because they've renewed you so many times, doesn't look like an expectation.
No, that strengthens your expectation. Every renewal strengthens your expectation of future renewals. That expectation is weaker if you're a part-time worker. And there's been some bad cases at universities with university part-timers back in the 70s, which we're actually fighting to try and reverse right now, because it's a completely different era. Part-time working was much more restricted in that era than it is now.
Wow.
But again, this is civil law, so you know I can't say this is
It
for
literally
certain,
is case by case.
because people think expectation of renewal. People think, do I expect to get renewed next year? That's what this means. Actually, no. It's legally reasonable expectation of renewal, which to put it in English means a judge thinks it's reasonable that you would get renewed, to be honest. And what the judge thinks is reasonable may be very different to what you think or I think is reasonable. So that's a problem with this. Okay, the company I work for claims that they're having financial problems, therefore can't pay our salaries on time. Is this allowed? It's not allowed. basically, companies have to pay wages on time and in full, in line with the Labour Standards Law. However, if you go down to the Labour Standards Office, the officers will make a distinction between a company that can pay and is willfully withholding wages and a company that is running out of money. And if it's running out of money, they're unlikely to prosecute. Well, what would be the point to prosecute to get money that it doesn't have? That's kind of their way of thinking. And in that situation, if a company goes bankrupt, there's a system called the Tatagai Barai Sega, where the government puts in, I think it's 60, is it 50 or 60%?
I think it's 80.
80%. Yeah.
Just 80.
80%. Okay, well that's more. So you can get money back if a company goes out of business, but initially, if a company is not paying you, maybe you should go to, again, if you're a union member, take advice from us on what to do there, because it does change with circumstances. But company not paying you, labour standards is a good way to get that money back. If it's just some two-bit employer refusing to pay you because you did something that annoyed them, then definitely going to the Labour Standards Office is the way.
With that thing that you just mentioned, if the company goes out of business, I'm a little unclear on what that means. So if the company goes out of business, the government will continue to pay your salary until the end of your contract?
No. Any money owing to you at the time it goes bankrupt,
I see, okay.
unpaid wages at the time it goes bankrupt, the government will pay 80% of that. But they won't continue to pay any more. Okay. Now this is an important one that I'll deal with here. My employer sent us home early from work the other day because there wasn't any work to do, and now he won't pay us for this time. Is the employer obligated to pay my wages during this period? Now, what this means is that it's basically thinking in terms of layoffs. For example, in a factory, you often get that. If it's for reasons due to the employer that they send you home, then it's 60% they're supposed to pay. How does this work in education? Now, the thing is, this works on a daily basis. So we've had a number of cases. It's very common for university teachers where you paid per class for 1.5 hour class, and you may have some elective courses. And the school's got a rule that if 5 students don't register for your course, the class is cancelled. And the question is, should you get paid 60% of your class? Actually, it doesn't work out like that, because the Labour Standards Law only seems to recognise days. So if you got 60% of the pay for that day, so if you had 4 classes in a day, 1 got cancelled, they could just pay you for the 3, and they're within their rights to do that. If you have 1 class in a day and they cancel that class, then you've lost 100% of your pay. They've got to pay you at least 60% for that class. So it's worked out on a daily basis, and they think in terms of days. So that's basically the problem there. But as long as you need to be paid 60%, I've even heard of it at some language schools even sending people home early, and they can do it as long as you get 60% for the whole day. How that fits in with
Sorry, I should let you finish, because I want to ask a question about renewals, which you seem to have moved on.
moved on from, yeah. So how that fits in with contracts, I don't know. If they if you only got 60% for the whole year or something like that, and they knew that was going to happen, would you have a case under the civil law? I'm not sure. It depends on the reasons, what was reasonable. Okay, so ask me about the renewal question.
I've been warned that my contract will be renewed and my hours will change, and I've had 6 renewals so far, and the hours have never changed in those 6.
Okay, so you've had 6 renewals. How long is your contract?
It's a 1 year.
1 year contract. Yeah. Well, what you should be doing right now is putting in a request for an indefinite contract for next year.
That's what I am.
Yeah, and if you do that, it should be with the existing conditions.
They seem pretty adamant about changing my hours.
Now, it could be complicated. If they just had kept the same hours but changed them around a little bit, they might be within their rights to do that. But in principle, it's got to be the same conditions. They may be able to set a retirement age if there wasn't one before, something like that. So there are some things they can do, but you know they're severely limited on what they can do. Okay, any other points on that? We'll be later on in the afternoon. We'll have the session on the labour contract law and the question of renewals and the 5 renewals and things like that. So we'll deal with that in a little bit more detail later.
Just, I was wondering if maybe on the union's website, does this general law exist in English?
The labour standards law, I've got a copy in English. I'm not sure whether it's on our website, but it's on the Labour Ministry's website.
If you just search Labour Standards Law, Japan, come on.
And yeah, you'll find it there. It's on the Ministry of Labour and Welfare's homepage. And, you know, it'll come out there. You search for it. Okay. What else on wages? Let's go on. We're on page 7 now. What's the maximum number of working hours you can work in a week? Well, the maximum working week is 40 hours over 6 days. So that's the standard work week. Now, anything over that is overtime. You can't be asked to work overtime unless they have an Article 36 agreement, which needs to be agreed with a union representing over 50% of the workforce or a workers' representative. And if they get that agreement, and this is the reason why a lot of non-union companies will have a workers' representative, very often management will go round, this is just to make this person a workers' representative, please sign this. And they'll go round and get the people to sign it. And that's because without that agreement, they can't get people to work overtime. So if you hear there's an election for a workers' representative, that's what this is about. What else? Overtime rate, 125%. If you work over what it says in your contract, say your contract says 30 hours and you work 35 hours on a week, they must pay you for that extra work time. However, they don't have to pay you at 125%. That's only when it goes over the 40 hours. And I believe after 10 o'clock at night as well. My son is working in a supermarket now and he gets paid extra when he comes back at 11 o'clock at night there. So, you know, you get extra pay if you go over those hours and if you go over 10 o'clock at night.
So to go back to the question that was asked before, if technically you're working, for example, on a part-time 20-hour contract, but weekly you work about 60?
Oh, then definitely something should be done about that. So where are you working now? Are you working there at work or are you at home?
Usually at work.
At work. Okay, I mean that's the kind of thing where labour standards probably would work. If you could show they could come in, look at computer logs, things like that.
Maybe when we're done, actually, if you want to stick around just for a couple of minutes, we can set up a proper consultation. We can go through it because if it's that clear, it's not that hard to deal with.
Yeah, our teaching hours and the hours we are physically working are very different.
Thank you.
Yes, yes. It happens a lot, and especially in the language industry. It happens tremendous. You know, it's terrible actually.
Yeah. Many people's teaching hours and class hours are different, but that to that extent is ridiculous. You know, it's far beyond the normal range of what you'd expect. Okay, what have I missed out here? Can I be fined for being late? Okay, this explains what a fine is. And it's not a fine if you're 15 minutes late and they stop you 15 minutes pay, it's not a fine. That's just, they don't have to pay you for when you're not in the workplace working. But if you're 15 minutes late and they fine you half a day's pay, that's legal. Not any more than half a day's pay, that's not legal. So there are limits that are set on fines. Again, this is the minimum. Your employer doesn't, you can't conclude from this that your employer should have fines or it's perfectly good for them to have fines. In our view, it's pretty terrible. But it's not illegal until it goes beyond a certain limit there. Okay, and the total, I think there's a total, hang on a second, fines cannot exceed 10% of your monthly pay. So there's a monthly maximum that fines can go to. Okay, just running through quickly. How many hours can I be made to work without a break? If your shift exceeds 6 hours, you must be given a 45-minute break. For a shift of 8 or more hours, you must be allowed a 1-hour break. Now, just to be clear, if you're expected to eat dinner with your elementary school students, that is not a break. That is work. And if you're required to do it, that's not a break. That's not your lunch break. You're working, you're supervising there. And they must give you a break when you're not eating dinner there, in that case.
When must that break be taken? I have many days where my break comes at the very last hour of the day.
I think that is wrong. Dennis, can you?
Well, the law says that it must be, it's a little bit unclear, but it should be in the middle of the day.
Right. I've
So,
read that online.
yeah, it doesn't say exactly right at halfway, but it is unreasonable that it's at the end.
How many hours do you work in a day?
Well, my days are all over the place, so
But give
on
me
a
an
long
example.
day, I'll work an 8-hour day, let's say.
8-hour day, and they make that 7 by giving you the last.
No, it becomes 9, basically. So I'd work for 8 hours, the 9th hour would be my lunch break.
Okay, you work for 8 hours, and the 9th hour will be the lunch break. I don't think that would work. I don't think they would be able to do that under the labour standards.
Some people, we always treat this a little bit delicately because there are some people who say, well, hell, I can go home an hour early that way, so I don't care.
Right.
But there's some people who think, I want to eat. 8 hours is a long time to, stay without eating or relaxing or nothing like that. So, I actually think the best way, again, the Labor Standards Office sometimes are like, it's such a big deal, well, what's the problem? Is sort of their attitude with that, right?
Right.
Probably often, depending on what the union's relationship is with that employer, it's probably easier to go through a union and just say, come on, this is unreasonable, let's work something out. I think that's probably the better way.
Okay, nice.
Okay, and which brings us on to the last point then in this, which is about national holidays, sick days, and annual paid leave. First of all, sick days. Are you entitled to sick days? Unless it's in your contract or your working rules, no. There's nothing in the Labour Standards Law about sick days. National holidays, no. They don't exist according to the Labour Standards Law. Of course they do exist, but they don't. Your employers are under no obligation to give you those days at all. What does exist is something called UQQCA, or annual paid leave. And the annual paid leave, after your first, if you're in full-time work, after your first 6 months, then you're entitled to 10 days paid leave, annual paid leave. And that increases by 1. So after 18 months, it goes up to 11. And that increases by 1 every year to a maximum of 20. Now, if you don't use your annual paid leave in 1 year, you can carry them over 1 year. So if you were 6 months, you've got 10 days annual paid leave, and you don't use any of them, then you'd have 20 in the next year that you could use. Okay. Now, the question of, now, if you're a part-time teacher, you're still entitled to annual paid leave, just not the same amount here. This table at the bottom of page 9 actually shows you the table here. So 5 days, 4 days, 3 days, 1 day in a week. You'll also see on the right side here the number of days a year. Now, our argument as a union, our position on this is that if you work Wednesdays, you should use the days of the week timetable. If you work all over, so some weeks you work Wednesdays, others Fridays, something like that, then it's appropriate to do the days a year. We're not sure that would always be ruled to be the case by Labour Standards Office. That's what we argue with employers, but who knows? I'm sure we actually have to check that out with the Labour Standards Office, see if they do have any internal regulations on what to do in that case. But that's our argument anyway for now. So yeah, it tells you your paid holidays there. Now, can your employer say you can have paid holiday, but you have to take them in the summer break when there's no classes? What do you think? Can they say that? Okay. Now, no. Anybody want to add? No. What?
I don't know.
Okay. Okay. Well, I'll tell you. They can set part of your paid holidays if they have an agreement with a union representing over 50% of the workforce or a workers' representative. And sometimes they will set those things, but I can't remember. There's a maximum.
Everything over, they can set everything over 5.
Okay.
5 should be reserved.
So the minimum so they've got to leave you with 5. They can't, but still they can take away and set a lot of those days annual leave. Okay. But they have to state that, and they have to have an agreement with a workers' representative that said they can do that, and they have to inform you that that's the case.
Chris has a question.
Yeah. So full-time, somebody who works full-time is entitled to 20 paid holidays per year. That
if they've worked there for.
I'm sorry, I'm imagining my personal situation.
Okay. But remember, your personal situation, these are minimums set by the law.
Right. So I should, as a 9th year full-time employee at my company, I should be entitled to 20 full pay days off per year, unless the contract stipulates that X number of days is to be used at this time.
No, you're still entitled to those days paid leave, but if the contract states that you must take 10 of them in July or August, or August to September, then they could do that. So they could stipulate 10 in this period, 10 in this period.
No, they can only stipulate up to 5.
No, 15. They could stipulate 15 in the summer and 5 elsewhere.
Okay.
ECC is probably a good example, because there is a fair bit of time off in the summer and the winter and things like that. A lot of those days they take as, they say, these are part of your paid holidays. Not all of them, but there's a part of them there, right?
Yeah, I don't recall ever seeing anything like that mentioned in my contract.
At Eon, because you don't have the long shutdowns like at ECC and stuff like that. So basically it's, it's impossible to sort of set them, right? Because there's never that much time off.
Yeah, and I have up to 5 days off per year. So that's something I want to look into a little more, I think.
At universities, they just don't tell teachers that they're entitled to the annual paid leave at all. So they don't encourage them to take them at all. And if you do take them in class time, obviously there's no need, because you get paid the summer anyway. But if you took in class time, a lot of places ask you to take up a makeup, ask you to teach makeup classes for the day you've missed, and there's nothing actually illegal about that.
Yeah, I'm just wondering, is this per employer or is it cumulative? Do you know what I mean?
No,
Like
it's-
I work for 4 different universities, so.
No, you would be, it's different at each university, so.
Okay, so it's per employer.
Yeah,
rather
per employer.
than- Okay.
You can't add them all together and get more and take somebody's holiday at a different
Not
university.
legally, you know what I mean? If I work, whatever,
No,
40
no,
hours a week.
it's
well,
all done as
different
with a
places.
single employer, so you would be classed, say, like as a 1 day a week or
Yeah,
something
yeah.
like that.
Sean?
On a similar line of questions, I once worked for a company who part of them did discharge nursing, and they got in trouble with the law because they were saying they were nurses when they weren't nurses, and so they shut down the company, opened it up the next day with the same employees, the same work structure and everything, but it's technically a different company. How would that be calculated?
Sorry, say that again.
So the company disappeared, and so, but the next day, a company of the exact same name with the exact same built makeup was created. Would my paid leave day start at 0 again in that situation?
Maybe
Yes.
yes and maybe no.
Uh,
I don't know.
Is this hypothetical?
No.
Just, sure, it's a theoretical case. Now,
No,
in
this-
theory,
This is a real case.
it
It's actually
happened.
happened.
Okay, now they've got an argument, it's a different company. If you can show that it's not, and the whole thing would be on whether they accepted it was a different company,
Mhm.
and whether they'd done all the procedure properly, the reasons for that.
Yeah.
But it wouldn't be simple to use labour standards just to do that. It would probably end up with, you have to file some kind of civil court case in order to deal with that. There are all kind of tricks employers can use. Even the best law, there are 101 tricks employers can use and do to get around the law. That's the truth of the matter. And, you know, there's lots of loopholes that need to be closed.
Already has a question.
Actually, to answer your question, they can, if you file a civil lawsuit, they can actually pierce the corporate veil and say that these are actually owned by the same entity, even though essentially they're 2 different entities. So in Japan, if you're, for instance, it's a parent company,
Yeah.
and then a subsidiary closes, and then everyone was absorbed by the parent.
Yeah.
If you file a civil case, then they will say that it's the same company essentially,
Mhm.
and you will still get your leaves.
Yeah.
But the difficulty here is to establish that those are owned by the same, essentially the same people.
Yeah.
So,
And your civil court case would probably take years again, and you would be paying. You would be paying for that as well. And this is the whole problem with the civil law, that you know it costs, and
but
the-
it would cost a lot,
it
correct?
would cost a lot to do that. So that's why, another reason why, even with the civil law, unions are important, because we won't handle every civil court case for people, but if it's a general principle, like at Nova, the question of worker status, then an organisation like a union can fight it. It doesn't mean that every time you have a dispute with the employer, if you're a union member, we pay your civil court fees. We don't. We just can't afford to do that. But if it's an important issue that has implications for a lot of other people as well, you know, there are times when we do that, as we did with the Nova worker status thing.